18.
18, my lord.
Millard, this matter.
18, my lord, I am for the petition.
Yes. Millard, I am for the. Millard, in this matter, Millard, yesterday, Millard.
Yes.
Yesterday, I drew my lord's kind attention to the order under appeal, Millard.
Your other
Now,
side.
Millard, the order under.
For appearing online, my lord.
Thou.
Now,
No, allow us to again refresh our memory. We'll just again go through the order once. The order is dated
6/5/2024.
ফোনটা কোথায় দেখ?
You're G+4 or G+5? What have you constructed?
My lord, they alleged, my lord.
Simple question.
No, Millard, I tell you, your lordship, Millard. Millard, there is, Millard, I disdain to conceal, Millard, the fact, Millard. And Millard, this is the fact, Millard, that the learned, before the honorable single judge, there was a clear answer, Millard, to the query made by the court. There was no mistake on the part of the advocate, and there was no gap between the instruction between the client and the advocate. No doubt about it. But Millard, the question is, Millard, that whether honorable single judge was justified in ignoring Millard, the order, Millard, which is at page 37, passed by the same honorable court, Millard, the honorable court, Millard, that how, Millard, the entire procedure is to be adopted. There is a complete, Millard, omission while Millard dealing with the issues. Now, Millard, under the Act 177, Section 177 of the HMC Act, Millard, the commissioner is the authority, Millard, to entrust with the power. Now, Millard, when the honorable court has laid down the procedure, but that this is the manner in which, Millard, the order has to be executed, Millard. Millard, any aberration, Millard, from the order, Millard, as directed, Millard, that is, Millard, possibly cannot be countenanced. Now, Millard, the merits of the case is a different aspect, and the procedural impropriety, Millard, which gives the rise, Millard, to move your lordship's court, Millard, that the honorable single judge should not take up the entire issue, Millard, on the.
Allow us to interact with the Howrah HMC. You're appearing for HMC.
Shantanu Chatterjee is appearing on HMC.
I'm happy.
Yes, tell us, what is your instruction?
My instruction, my lord, kindly comes to my lord, the page 51, my lord. I need to find, my lord, that we have already given a hearing, my lord, and accordingly the order has been passed, my lord, in terms of page 51. Page 51, my lord.
Mr. Chatterjee, the only grievance, if we may say so, of the appellant is that the order of Justice Sarkar, which was passed in the earlier petition, has not been followed by you. The order
kindly come to page 51 once, my lord. It is written there, my lord. Kindly come to page 51. Justice Sarkar order was passed in WPA number 676, my lord.
676.
My lord. In terms of that order, my lord,
No,
hearing
no,
has been given, my lord.
no. 2046.
My lord, 20466. 046, my lord. I apologize, my lord.
State তো পাঠিয়ে নি স্টেট পাঠিয়ে নেই বাবা দেখো কোথায় পাঠিয়ে স্টেটের কাছে গ্রিভেন্স ছিল
Inspection হয়েছে সবই তো। Mr. Bose, everything has been complied with. Joint inspection report was there.
Milord, I tell your lordship, Milord, before hearing, Milord, that at the hearing, Milord, that was taken place, notices were sent to the wrong address, Milord, not, Milord, to the address, Milord, the proper address, number one. Number two, Milord, no sketch map was extent of the
Notice of what?
notice, Milord, of hearing was given, Milord, to the address of, Milord, the landowner, not to me, Milord, I am the developer. Second, Milord, the no sketch map, extent of, Milord, the violation not given to me. Number three, Milord, that adjournment petition was made on the day, Milord, when the hearing was supposed to be given on account of the illness. And Milord, this was turned down. And virtually, Milord, no pseudo hearing. And there was a complete pseudo compliance. Milord, unless I get to know, Milord, that what is the area of violation, the sketch map, inspection, Milord, that was a pseudo compliance. Nothing was there. Now, Milord, in paragraph 14 to 17, 18, Milord,
This is the
I have
problem.
categorically stated.
He's the developer, my lord.
Problem of
He's the
virtue.
developer, my lord.
Suresh is the developer.
Developer. And my lord, notice has been served upon the landlord, address of the landlords, my lord. My address is written in the cost title, my lord. And page 49 is my lord, letter to reschedule.
So you did not appear at the hearing.
No, my lord, because
No,
no, my lord.
the order records so.
My lord, that is the question, my lord. My lord,
And Milord, I have categorically stated, Milord.
My lord, kindly come to page 49.
Sorry.
Kindly come to one for a moment, page 49, my lord. Page
Now,
49.
Milord, I have one judgment to show, Milord.
Page 49. Kindly see, my lord. There is my letter. Just day after the, my lord.
Sir, we have heard two matters in this area. Our experience, demolish the buildings.
My lord, I may not have any case.
Milord, only one judgment, Milord. I wish to take my lord's kind attention to paragraph 50 reported in, Milord. This was, Milord, earlier placed on which, Milord, your lordship directed the Bidhannagar municipality to reconsider the issue, Milord, where, Milord, the unauthorized building was constructed by the developer, and, Milord, the Honorable Justice Gangopadhyay had passed certain orders that was set aside, Milord, and, Milord, ultimately, Milord, your lordship directed the authority to reconsider, which is reported at, Milord, 2006, 8 SCC, page, Milord, 590. Milord, page 2006, my learned junior, Milord, is armed with the judgment. Milord, in that case, Milord, here, Milord, I, Milord, beseech your lordship, Milord, to have the charity to consider, Milord, the paragraph 53. Here, Milord, the principle of law possibly subject to what my lord will say, that may I read for my lords, it is seen that no notice under such and such has been issued by the municipal commissioner in this matter against the appellant. In this special leave up, page 53, paragraph 53 of this judgment, Milord, which says, Milord, it is clearly mentioned by the appellant that the corporation had received notice to stop work under such and such of the BMC Act. No reference is made to any notice under section 351 of the Act. It is specifically mentioned that the affidavit which was filed on behalf of the corporation had categorically stated that after service of the stop work notice under section such and such, no work was carried out. Respondent number 1 is fully aware that the provisions of section 354A of the Act deals with stop work of notice, whereas the provisions of section 351 of the Act deals with the show cause notice for demolition of unauthorized structure. The grievance of the appellate herein has been without issuing a notice under section 351 Act and without giving an opportunity to appellant being heard, the structure of temple could not be ordered to be demolished by the High Court. The power under such and such of the Act, in our opinion, has to be exercised by the Municipal Commissioner, and it is left to the Municipal Commissioner under the provision of such and such either to order or not to order the demolition of the alleged unauthorized temple. In fact, the respondent number 1 by himself, through his advocate's letter such and such, annexed to request it to the municipal authorities to take action under the section 351 of the Act. At the time of admission of this special leave petition, the provisions of this Act, such and such section of the Act, was pointed out by the learned senior counsel to show that the municipal commissioner had only been conferred the power under the said provision to demolish or not to demolish the unauthorized structure, and therefore the High Court ought not to have issued a mandamus for demolition of the temple before any order was passed by the commissioner on the question of demolition. The provision of such and such, Milord, here my respectful submission is this, Milord, it is the commissioner under the 177 of the Act that empowers the commissioner. But, Milord, there is a point of interpretation which might stand against my client, that either he or any authorized or delegated officer, Milord, but the person concerned who has, Milord, passed this order, whether he is the proper delegated authority or not, Milord, that is not before us, neither here nor there. Milord, that is my respectful submission. So, Milord, hearing the each and every step of the order of Justice Sarkar, Milord, has to be complied with. And, Milord, the Honorable Single Judge did not whisper as to whether such compliance has been made. This order was passed under appeal, Milord, only on the basis of the oral admission made by the advocate, Milord, addressing the Honorable Single Judge. So, Milord, may I beseech your Lordship, Milord, to direct the authority to reconsider the issue in the light of the judgment or order passed by the Honorable Justice Sarkar. Milord, that is my respectful submission. I leave it to your Lordship.
Yes.
Milord, may I take my Lord's kind leave?
Yes, Mr. You're in Jalpaiguri.
No, Milord, I am in Calcutta, Milord. Other courts, Milord, I can. So
Okay.
sorry.
All right.
Deeply obliged, Milord.
So one thing I may add, my lord, I received the information on a later stage, my lord. The complainant in this case, my lord, already has filed a civil suit, and the civil suit already granted, my lord, some, my lord, order of interim order, my lord. Kindly see, my lord, this. A civil suit is pending, my lord, regarding the same illegal construction, my lord.
Who has filed? You have filed this?
No, my lord. The complainant, my lord.
The order is in your favor.
No, yes. Sometimes some portion is in my favor, my lord.
What does
Because,
it
my
say?
lord, the learned
It says the illegal portion cannot
No,
be
no.
demolished.
learned court, my lord, directed to construct the remaining portion. Kindly see the, my lord, later portion, my lord, order portion only.
Not necessary, sir. No court order will override High Court's order,
Definitely, my lord.
right?
This order
Yes,
portion in April, my lord. That's why.
You have tried your best, sir. Your client ran the risk of demolition by constructing 5 floors without sanction plan.
Maybe, my
I
lord.
have no sympathy for such people. You may go higher up and try your luck.
My lord, no opportunity has been given, my lord. That has been
We don't
regulated by
believe your client. We don't believe your client. We'll record so. Right? A judgment and order dated May 6, what's the date? 2024. Passed by a learned judge of this court on a writ petition filed by the appellant herein, being WPA 22606 of 2022, is under challenge in this appeal at the instance of the writ petitioner. Paragraph. It appears that the appellant obtained a sanctioned building plan for constructing a building plan from Howrah Municipal Corporation, bracket A, in short HMC, bracket close, for constructing a G+1 storied building. at premises number 41 and 43 by 2 Surendranath Chatterjee Lane, under the territorial limits of Howrah Municipal Corporation, within the territorial limits, within of HMC. আগেরটা HMC করে দিও ব্র্যাকেটে of HMC. Stop. Joyanto Rai had filed a petition for complaining of unauthorized
For
construction.
implementation of the demolition order, my lord. He is the complainant. And the writ petition is also, my lord, pending, my lord. Returnable date is 11th June.
Joyanto Rai's writ petition is pending.
No, my lord. This writ petition,
There
my
is
lord.
order passed on Joyanto Rai's writ petition.
But that is, my lord, page number, my lord. That is, my lord, at page, my lord, 42,
42.
675-2022. That became infractuous, my lord, due to, my lord, order of
67.
page 42,
Yes.
76 of 2022.
Yes. So this was the prior writ petition.
In the light of, my lord, 2046.
So he had filed for implementation.
Implemented.
And you filed challenging.
Challenging. And in that case, my lord, the order has been.
It appears that of G+1 story within the territorial limits of HMC. Stop. However, he ended up raising a G+5 story structure. Stop. Paragraph. 1. Joyanto is your neighbor.
Never.
A neighbor of the appellant hearing, namely, Joyanto Kumar Roy, filed a writ petition being WPA 676 of 2023 or 22.
22.
22, for implementation of an order of demolition dated January 27, 2022 that had been issued by the concerned assistant engineer in charge, building department, HMC, directed against the alleged illegal construction raised by the appellant herein. Stop. The appellant, on the other hand, filed a writ petition being WPA 2046 of 2022, challenging the order of demolition on various grounds. Stop. Paragraph. A learned judge of this court, disposed of the present appellant's writ petition by a judgment and order dated February 9, 2022 with the following directions. Page 38 থেকে 38 or 39. Paragraph. Insofar as Joyanto's writ petition is concerned, in view of the order passed in the present appellant's earlier writ petition, the learned judge observed that the prayer in Joyanto's writ petition does not survive. Accordingly, that writ petition was disposed of by an order dated February 11, 2020. Paragraph. HMC says that pursuant to the order dated February 11, 2022 passed by the learned single judge in the present appellant's earlier writ petition, joint local inspection was held, stop, hearing was held, stop, the appellant participated, stop, An order of demolition was passed on August 8, 2022 by the Assistant Engineer in Charge, Building Department, HMC. Stop. Paragraph. Challenging such order, the present round of litigation, you challenge this order.
Yes, my lord. That is
That-
pending, my lord.
Yes. Challenging the said order of demolition, the appellant approached the learned single judge in the present round of litigation. Stop. Paragraph. The learned judge noted that pursuant to the order dated February 11, 2022, passed in the earlier writ petition of the present appellant, HMC had held local inspection, hearing, and only thereupon had passed the demolition order. Stop. The learned judge noted that the second, third, fourth, and fifth floors of the building in question have been constructed without any sanction at all. Stop. There are also deviations insofar as the G+1 storied structure is concerned. Stop. To a query raised by the learned judge as to whether or not the writ petitioner has sanction for construction of G+4-storied building, there was no answer. Stop. The learned judge held that a person responsible for making construction cannot raise any structure beyond the sanction plan. Stop. The HMC having detected unauthorized construction, such construction must be demolished. Stop. Insofar as the deviation in the G+1 floor level is concerned, the learned judge observed that a further opportunity may be granted to the writ petitioner to defend his stand. Stop. The learned judge directed immediate demolition of the floors that are not supported by a sanctioned building plan. Stop. The learned judge directed police, the jurisdictional police station to directed the Howrah Police Commissionerate to render all assistance to HMC for implementing the demolition order. Stop. The writ petition has been kept pending and has been directed to be listed on June 11, 2024. Paragraph. Being aggrieved, the writ petitioner has come up by way of this appeal. Paragraph. Appearing for the appellant, Mr. Kornul Bose, learned senior counsel, submitted that the order dated February 11, 2022, passed in the earlier round of litigation, was not considered by the learned single judge in the present round of litigation in its true spirit and intent. Stop. That order had laid down the manner in which HMC was required to proceed in the matter. Stop. HMC did not do so. Stop. Therefore, the learned judge in this round of litigation ought to have directed HMC to adhere to the earlier order dated February 11, 2022, and ought not to have directed implementation of the demolition order issued by HMC. Stop. Paragraph. We find absolutely no merit in such a submission. Stop. We find from the demolition order itself that joint inspection was held, stop, hearing was held, stop, the appellant uh, appeared in such at such hearing, stop. Therefore, comma, the order dated February 11, 2022 was duly followed by HMC uh, in holding the demolition proceedings, which culminated in the order of demolition. Paragraph. Mr. Bose also argued that the order of demolition has been passed by the assistant engineer in charge, building department, HMC, when the appropriate authority is the commissioner of HMC, stop. We see no merit in that, in this submission also, stop. Under the HMC Act, yes, Mr. Shantanu Chatterjee,
So I have,
Junior is
you are there. In the under the HMC Act, there must be power of delegation.
Lordship, I do not have knowledge in this matter. I think his connection has been
You
lost.
do not have knowledge in this matter. You are appearing for HMC.
I am not appearing for HMC. I am appearing on behalf of Mr. Santanu Chatterjee.
You are appearing on behalf of Mr. Shantanu Chatterjee. What is going on?
literally, my lord, there is no such, my lord, 7 except, my lord, section 25. But that these 177 needs, my lord, special delegated power. It is my submission, my lord. My lord, I have one copy of book. Pardon me.
Ki bollam? Under section 28 of the HMC Act, there is power of delegation by the commissioner to discharge his functions. Power of delegation by the commissioner to any other officer or employee of the corporation to discharge his functions. Stop. We shall presume that the official work done by KMC has been done properly and lawfully. Stop. Bracket it out. See section 114, bracket E of Evidence Act. Paragraph. We find no infirmity in the demolition order, nor any merit in this appeal. Stop. A citizen who is reckless enough to build 4 extra floors, 4/5, 4/5 extra floors, without obtaining due sanction therefore from the competent authority, deserves no sympathy or indulgence at all. Stop. The learned judge has rightly directed implementation of the demolition order. Stop. We affirm the order of the learned single judge in its entirety. Paragraph. This appeal therefore fails and is dismissed along with the connected application with costs assessed at rupees 20,000 to be paid to the High Court Legal Service within 2 weeks from date. ছুটি হয়ে যাচ্ছে তো তুমি তাহলে করো by June 10, 2024. Stop. Let a copy of this order be forwarded to the member secretary of same High Court here, who should bring to our notice any failure on the part of the appellant to deposit the costs as directed in this order. Stop. Paragraph. Let the matter be listed under the heading to be mentioned on June 11, 2024, only for the purpose of ascertaining whether the costs have been paid by the appellant.
My lord, humbly submit, my lord. Kindly reconsider, my lord, about the cost, my lord. Kindly, my lord, because, my lord, I am not in a position, my lord,
You are not yet?
in such position, my lord.
You're not in a
Because-
position. You can build 5 floors without sanction.
Yeah, it is my humble, my lord.
It'll go up. It'll go up. Don't-
Kindly, my lord.
Sorry.
reconsider, my lord.
These people must learn, sir. Must learn. Chalo, next matter. And we assure you, tell your client, if on 11th we find he has not deposited the cost, unless the Honorable Apex Court sets it aside, then this cost will immediately become double and then again double. So,
My lord, kindly, my lord, reconsider to, my lord, minimize the cost, my lord.
No.
Kindly, my lord.
no.
It is my humble prayer, my lord. Humble prayer, my lord.
Considered,
Humble prayer,
considered.
my lord.
We have
I
considered
appeal
you.
for Apex Court, my lord, kindly, my lord. Kindly, see, my lord, kindly not consider, my lord.
You persuade my brother?
My lord, kindly, my lord. But kindly, my lord, reconsider, my lord. Because the
Next.
20,000 is enough.
Well, matter.